Michele Conti here of Conti Law. Let's talk about a minor beneficiary inheriting from your estate. We're going to use my own children as the example. I have 10-year-old twins, and the intention is when my husband and I die that they will inherit our estate equally. What if you don't have a will? What if you have a will and you don't put the appropriate language in there? So in both scenarios, there's different outcomes. If you die in Pennsylvania without a will, then Pennsylvania intestacy law tells us who inherits. So in my example, if my husband had predeceased me, then everything by law will be divided between my kids. That's great. However, what if they're under the age of 18? Or in my situation, I don't want them to inherit at 18. So what if they're under the age that I feel is appropriate for them to inherit? Well, if you die without a will, it doesn't matter. Pennsylvania will release the estate to your next of kin, which in my example is my two children. If they haven't turned 18 yet, then the state, through the court, will appoint a limited guardian to manage their inheritance until they turn 18. Now, I primarily practice in Western Pennsylvania, Allegheny County, Beaver County, Westmoreland, Washington, and typically the court is going to appoint the attorney to manage those funds for the minors until they turn 18. In my opinion, 18 is too young. I don't think an 18-year-old should be given a blank checkbook and allowed to use those funds as they wish. So if you feel the same way, it's important to have those provisions drawn up in either a will or a trust. Now, in a will, you can leave what's called a testamentary remainder trust. That's a fancy way to say you can leave the estate to your children and put different terms, whether it's ages or situations, when they are going to receive the inheritance. So in my document, it says that if my children haven't attained a certain age, which is 45, then the funds will be held in trust and be distributed based on not only my trustee's discretion, but at the age of 25, they'll receive a third, they'll receive a half at the age of 35, and the balance at 45. Now, traditionally, most clients are not as conservative, and they leave the funds to the child in the trust until they turn 25. That's fine. It's all personal preference, but it's important to know that you can leave these remainder trusts, whether it's in your will or it's in a trust. Now, what about my retirement, my life insurance, any of those accounts that I may have that have beneficiary designations on them? Well, again, if I have $1 million life insurance policy and I die and they're 18 years old, I still don't want them to each receive $500,000. So what we do is we make sure to coordinate the beneficiary designations and make the designations match the terms that are either in my will or trust. And so by working with an experienced estate planning attorney, they can assist you in updating those beneficiary designations to reflect the age or ages that you've stated in your will or your trust instrument. But depending on how your child will inherit, or grandchild, niece, nephew, it doesn't matter, but how that beneficiary will inherit, we need to make sure the appropriate verbiage is actually in the will. We don't want to make it so that if they're a minor and they inherit it, or if, let's say they have a drug problem, let's say they have an addiction issue, let's say they're gamblers, let's say they're in the midst of a divorce, or they have special needs, we can utilize a remainder trust in all of those situations and put the appropriate language in your will so that when you pass away, we're not letting it up to the discretion of the court, or when they turn 18, allowing them to inherit everything outright. If you have any other questions, feel free to leave them in the comments section.